The next case to come before the court is State of Ohio v. Donald Mims. Are you both ready to proceed? Are you waiting on anything? Okay. All right. Each party will have 15 minutes to present your argument. The appellant may reserve up to 5 minutes for rebuttal. If you would like to reserve time, please let me know, as I'll be keeping track of the time. The arguments are being recorded, so please introduce yourselves, stay behind the podium, keep your voices up. You should not use the names of children or minors or victims. You can use initials or generic terms. The judges have read your briefs and we're ready to proceed when you are. And Attorney Bremke, I would just ask, would you like to reserve time?
I would reserve 5 minutes of my time. Good morning, Your Honor, again. Giovanna Bremke on behalf of Mr. Donald Mims. Mr. Mims was charged, I have sort of a chart here in my brief on the 3rd page, but with 8 counts and 2 specifications. He was convicted on some of those. 1 was found not guilty and there was some dismissed by the state. This was preceding a jury trial. I have presented 4 assignments of error. The first deals with, and 2 of at least 2, many of them deal with the firearm and whether that was operable and the test performed on that firearm. So what had happened was Detective Garvin had got up and said he wasn't sure whether the firearm was operable or not. He had not performed any testing. Over the defendant's objection, the court permitted Detective Garvin to put a pencil into that gun and test operability in front of the jury. My first assignment of error is that the court erred in accepting the testimony pursuant to evidence rule 703 and 704 because in that capacity, Detective Garvin was acting as an expert. The testimony regarding operability of a firearm is not within the purview of a knowledge of a lay person, so it is expert testimony. He did not provide any report in his police report or otherwise prior to the trial about the operability test and the theory, procedure, test, experiment, and whether that was based on something that was objectively verifiable, pursuant to evidence rule 702C1. And that's clear that he didn't do that because he performed this test for the first time in front of the jury. And again, the testimony supports that. That's transcript page 276. He indicates to the prosecutor upon questioning that he hadn't performed any testing. And that's when the court, again, over the defense objection, proceeds to allow him to perform that test, inserting the pencil into the firearm in front of the jury for the first time.
But there was testimony that officers had done that previously, not him personally.
I don't believe that that's the case. He said that when he was asked about whether the firearm was operable, he asked, is this operable? And I think his assertion was, I don't know why anyone would carry around a firearm that's not operable. But what we know is that people do that. Even kids carry around fake firearms, things of that nature, and that's why the General Assembly has indicated here that this needs to be capable of propelling projectiles.
Do you know of any case law where there's a requirement that there's an expert on operability?
Well, I don't know that that's the issue here. The issue here is when he did that test, he was acting as an expert, and he, was doing it for the very first time in front of the jury, and that kind of segues into my second assignment of error, where, I talk about how the defense objected, saying, I don't have the opportunity to effectively cross-examine on this issue because it's for the first time being performed in front of the jury and myself. So he wouldn't have the opportunity to counter that testimony because it's being performed for the very first time in front of the jury. So he, did raise that specifically. His objection was on, the issue of his inability to be able to cross-examine, because it's being performed for the very first time in front of the jury.
And counsel, not to go down this path too far, but I guess I'm a little bit confused by the briefs because I thought from the state's brief that the officer had done this previously before it was done in court. Would that matter?
No, well, yes, it would matter. And I will stand by my statement
Okay.
that, in fact, the exact question that I have on page 276 is, do you believe this firearm is to be operable? And the detective says, I don't have anything to say one way or the other. And then the question, and he goes on a little bit on that, but that's when he says doesn't make sense for anyone to carry on a firearm that's not operable. And then the prosecutor asks, did you perform any test to see if it's operable? And he said, I have not performed any kind of test to demonstrate that. That was the direct response. So I don't know where the confusion is there, but I would assert that this detective specifically said he did not perform.
He personally did, but there could be testimony potentially that other officers did that previous to his testimony. Do you think that's?
I don't recall that being the testimony.
Thank you.
And into my third assignment of error, the sufficiency, again, on the specific issue of whether the gun fit within the definition of 21.23.11b, and that requires that the firearm is capable of expelling or propelling projectiles. And he did testify, and I just read snippets of that he wouldn't be able to say one way or the other that this firearm was capable of being operable. And he did, again, specifically say he did not perform any testing to that regard. The only thing to support that is his assertion that it wouldn't make sense for someone to carry an inoperable firearm, but that's not enough to meet the definition under 29.23.11b. And lastly, the fourth assignment of error, that there was a jury misconduct. So in this case, the trial court did not permit note-taking for the jury, and it came to the court's attention that one of the jurors was taking notes. And in this regard, the test for jury misconduct is two parts, whether there was misconduct and whether that was prejudicial. I think that it's pretty clear that there was jury misconduct because the court repeatedly asked that the jury not do any outside homework, which, and asked that they not take notes. The court did not provide any note-taking ability, and I believe specifically instructed that the court does not permit note-taking at the beginning of the trial.
Do you agree that that's a judicial preference? There is a note-taking instruction that the judge can give the jury that's an OJI, so.
Well, yes, it is a judicial preference, but the prejudice here is that one juror is taking the notes. It's clear that there was misconduct because even the court, dismissed that juror for purposes of taking that note. But although that one juror was dismissed, there wasn't any questioning of the other jurors to see whether they were influenced by this note-taking. And I think that in the event of the judicial preference to allow for the note-taking, that's different because everyone has the opportunity to take the notes, and maybe there's competing notes back in the jury room. In this case, there was the one juror who had the notes, and the court failed to conduct that second part of the interview to show whether there was prejudice to the other jurors in that they were sort of relying on this one individual's notes. So, and I would submit to you that the fact that the court found that there was, that he dismissed that one juror is enough to amount to the misconduct there and prejudice because the court did not have an alternate at that point. The court made an assertion to that effect. So I would reserve the rest of my time, or up to 5 minutes, but ultimately I would ask that you reverse. Thank you.
Thank you, counsel. You will have 5 minutes and 45 seconds.
Thank you.
I'm sorry, 5 minutes. You'll have your full 5 minutes.
Good morning, Your Honors. Lindsay Paparaki of Lorain County Prosecutor's Office on behalf of the state. Mims' chief complaints on appeal center around trial testimony regarding the operability of the firearm and whether the state presented sufficient evidence of that firearm's operability to sustain his convictions for having weapons under disability. Mims' first assigned error begins with an argument that is flawed from the start, as he mistakes Detective Garvin's trial testimony about the operability of the firearm by use of a pencil test as expert testimony. But the Ohio Supreme Court has stated that proof of the existence of a firearm may be based on lay testimony and is not dependent upon an empirical analysis of the gun. That was in State v. Murphy and is cited in the state's brief. And to the extent that Mr. Mims makes this argument, his exact argument, as cited in the state's brief, has been rejected by the 8th District Court of Appeals. The argument that a detective's testimony regarding the pencil test be considered expert testimony was twice determined to be flawed by the 8th District, who concluded that an officer's testimony regarding his perceptions of a firearm's operability was proper lay testimony and pursuant to Evidence Rule 701. The CB case that is cited in the state's brief is exactly almost on point with this case. Their firearm was loaded and recovered in the vehicle. The officer testified to having performed a pencil test on the firearm and then described how the pencil test worked in detail. The 8th District determined that the testimony was based on the officer's personal observations and surrounding the incident and his examination of the firearm, and it was not empirical analysis of the gun for which expert analysis was required. We would ask that this court review that case, and much like the officer in CB, Detective Garvin's testimony reflected his personal observations surrounding the examination of the recovered firearm. And I would point this court to testimony of Detective Garvin specifically. He did not personally perform a test fire on the firearm, but there is specific testimony in the trial transcript where he states, and this is at transcript 275 to 276. So he says, so we didn't do any kind of test to, let me phrase it this way, we didn't put ammunition in and see if it would fire a lock round. We did stick a pencil in it. We put a pencil in to see if the hammer would fall, strike the firing pin, and eject the pencil. And that was successful. Detective Garvin's testimony was simply properly allowed as lay witness testimony under Evidence Rule 701.
Counsel, did they actually do a demonstration of the pencil test during
They did.
the court hearing? Okay.
Detective Garvin did, yes. And as to the second
And the
assignment
pencil
of error,
test, one more thing, the pencil test is basically takes the place of a projectile, like that the gun could actually fire a projectile. So it's simply that, correct?
that's my understanding, correct. And like in the CB case, they said this is something that an officer can testify to, and it's a test that's commonly understood, and it doesn't fall within something that an expert needs to testify to or demonstrate, because again, empirical testing as to operability is not necessary. And as to the second assignment of error, it's unclear to the court in what way Mims' ability to cross-examine Detective Garvin was limited in any way by the trial court. Defense counsel objected to the admissibility of Detective Garvin's testimony regarding the reliability of the pencil test, but he did not object on the basis that his ability to cross-examine Detective Garvin was in any way limited. In fact, defense counsel had full ability to cross-examine Detective Garvin and initially began his inquiry of Detective Garvin by asking him questions surrounding the recovered firearm. And Detective Garvin even conceded that if he had anything to do better, he may have conducted a test fire of the firearm. Mims, in his brief, has simply not identified any place in the record where the alleged error occurred, or if any questions that the trial court prevented him from asking Detective Garvin, and that flaw is fatal to his argument. As to the sufficiency argument, that should also be rejected. While the state must prove operability of the firearm, it is entitled to rely on circumstantial evidence, including but not limited to any representations of the person exercising control over the firearm. Again, empirical analysis of the gun is not required to prove operability. Cases cited in the state's brief illustrate that courts have held that evidence that a gun was loaded, combined with the submission of that gun into evidence, is sufficient to prove operability. Here, again, Mims' brief cites to a mere portion of Detective Garvin's testimony in an effort to lead this court to believe that the firearm was not operable. But this tactic simply ignores the remainder of the evidence, which supports the conclusion that the firearm was in fact operable. That evidence was more than sufficient to prove the state's case. First, the responding officer testified that he removed a loaded firearm with a light source from the passenger side of Mims' vehicle. The officer testified that the gun was loaded at the time and identified it as State's Exhibit H at the trial. Detective Garvin then testified that upon being assigned the case, he took possession of and handled that firearm, which he also identified as State's Exhibit H at the trial. Then came Detective Garvin's testimony about the pencil test, and the state further offered the firearm into evidence. Based upon the totality of these circumstances, the jury could have easily inferred that the firearm was in fact operable. And finally, as to the issue of juror misconduct, the state submits that the trial court did not err in failing to declare a mistrial because Mims has failed to demonstrate prejudice. The state acknowledges that at the outset of the trial, the court instructed the jury that it would not permit note-taking, and that a single juror did in fact take notes, some notes as she advised, to help her memory. And to the extent that this constitutes juror misconduct, the question becomes whether that conduct materially prejudiced Mims' substantial rights. And Mims, according to the case law, has the burden to establish prejudice. And it's important to note that the trial court is in the best position to fashion a remedy, the appropriate remedy, if juror misconduct occurs. And at the outset, I think this is important, that the majority view in Ohio is that the mere fact that a juror has taken notes during the trial does not in and of itself constitute unfair prejudice to a defendant. And I think that's probably in regards to the fact that there is a preference for in their decision, it's their decision whether or not to allow note-taking to take place in the first instance. And while Mims might have established that a juror violated the jury's instructions on note-taking, he has not established prejudice. The trial court questioned the juror on her note-taking. The record does not reflect that the juror's notes were shared or distracted any other jurors.
My understanding is they were confiscated?
They were confiscated. The trial court admonished the juror on her actions, and there's no indication in the record that the note-taking continued or distracted the other jurors in any other way or anything anything else in that regard. And the fact that the trial court chose not to declare a mistrial should not be second-guessed by this court. He was in the best position to determine the remedy at that time. And for those reasons, the state asks that Mims' convictions be affirmed.
Thank you, counsel. Attorney Brumke, you will have your entire 5 minutes for rebuttal.
Yes, Your Honor, just briefly to touch on some of the things the state had said. The defense counsel's objection was on page 276 and indicated that there is no known standard for this pencil test. The inability to cross-examine on this pencil test, it wasn't previously disclosed. I don't think the state mentions that. There was no, again, and this goes to my first and second assignment of error, but there was nothing that would indicate that this operability would, the test for operability would have been previously disclosed. I think that it's important to note that the state is one question, and maybe there's even confusion from others in the room about whether this pencil test, the purpose of it. And I think that goes to show that the operability of a firearm is not within the purview of a layperson. Because we're probably all questioning here how this pencil test is able to show operability. And that, that is not something that probably an ordinary person would know to do to show operability. So I would say that that is within the purview of an expert. And as to the fourth assignment of error, the juror misconduct, I would just note that it appears the state does agree that there was misconduct. The issue should come on the prejudice, and I would submit that there was prejudice in this case. So I would ask that you reverse the conviction. Thank you.
Thank you very much. Thank you both for your presentation. The court will take the matter under advisement and issue a decision in due course. The clerk of courts will mail that decision to you on the day that it is released, and it will also be posted on the Ohio Supreme Court website. Thank you both.